This is Mark Kemp of LasVegasProbateGuide.com with your 2-minute probate tip. The third where of probate is where did the decedent own property at the time of death. Now in this case, I'm primarily interested in real property assets because all of the personal property assets, such as bank accounts, automobiles, stocks and bonds, household furniture, all of those items will be handled in the main probate filed in the place of residence. But for real property, we need to have a probate in every state where the person owned real property. Now, if the person only owned real property in Nevada, the main place of probate, that real property is handled in the same probate proceeding as the personal property. But in every other state where there's a real property interest owned, you have to have what we call an ancillary probate case, and that's a probate in each state for each particular item owned in that state according to that state's laws, rules, and procedures. When we talk about real property, I'm talking about owning more than one residence, the vacation home in another state. It also would include raw land. It also would include timeshare interests that are held by recording. So sometimes there's a vacation license agreement where it's a personal property interest, but if you acquired a timeshare by recording a deed, you have to do a real property transfer in that state, and that will require complying with that state's probate laws for that real property transfer. So the third where of probate, where did the decedent own property at the date of death?